So the big question is, what does this mean for me? What does it mean for the firms I work for or the courts I work in, for the administrators, for the judges? So we as court reporters, we work within systems. We understand that administrators and attorneys have a duty to find efficiency and cost saving wherever they can. We understand that that's whether you're a private counsel or a public defender, whether you're civil or criminal, everybody's looking to find solutions to make cost savings and make things more effective. We understand that. So what are courts and law firms considering when they choose where to adopt new AI-driven technology into their systems? Many government bodies and associations have implemented these task forces or working groups to provide guidance to their counties and to their governments across systems. We'll look at some of those laws and legislations in the next section, but for now, let's say that you are a court or a law firm considering a new tool. So this list that I'm about to show you is lifted from the interim guidelines for use on generative artificial intelligence in Snohomish County, where I work. I recently joined a working group on AI that is county-wide. So it's not just for our Supreme Court, but it's for the entire county. And all I had to do was ask, and they let me on. So this list is a list of things that they want to consider when they're thinking about tools they want to implement. It's important to note that these guidelines apply to all departments, not just the courts, and they are based on both state and national guidelines. So while what's in this list may not be exactly what governs in your area, what you have is probably going to be very similar to this. So let's go ahead and see the first one. The first bullet point is safe, secure, and resilient, which means you have a duty to minimize potential harm. Systems have to be reliable, resilient, and controllable by humans. AI should not endanger human life, health, property, or the environment. So based on what we've heard today, there's a huge amount of data in audio processing and files and AI. Those data center storage concerns, the power needs used for AI, the data breaches that can happen in courts that can shut down systems. We had an issue of this in our courthouse just a couple of months ago where there was a data breach in the server, the third-party server who houses all of our court data. They went down. And so our clerks were not able to work. They worked in hard copy for weeks because all of our systems simply went down. They were not able to record. They were not able to even enter exhibits. There was a backlog that took them weeks to get back through. The thing that didn't go down was the court reporters, because court reporters, a stenographic or a voice reporter, we work on independent closed loop systems. We have our steno machine, we have our independent laptops. We can take a record and, if need be, we can hold on to that transcript until the site comes back up and then we submit. But it means that we are an extra bulwark, an extra firewall of safety between the courts being able to operate and bad actors. So we can sufficiently say that AI does not meet the first criteria. Second criteria that they consider is valid and reliable. Are there accurate and valid outputs? So can you rely on system performance when you're considering a tool? With AI and ASR, we know that we have poor quality, equipment failures and corruptions, as we've seen on Judy records. We have hallucinations, data drift, catastrophic interference, and then we have just plain old human error. Happened in one of my courtrooms recently during an open docket with 20 lawyers walking around the room. Nobody thought to turn on the microphones. So we were all in a room with each other. We could hear each other up at the bar, but any kind of recording system would not have caught anything that happened during that session. And I apologize for the crying baby in the background if anybody can hear. So what happens when any of these systems fail, or when one of the 90% of your AI startups fail? It results in a new trial. So we can effectively say that that crosses number 2 off the list. Number 3 is fairness, inclusion, and non-discrimination. AI can be an opportunity to support and uplift communities, particularly those who are historically marginalized. But any of these systems must address equality and equity concerns, such as harmful bias and discrimination. And what we've seen in our studies of ASR and these sort of algorithmic bias when it comes to race, gender, dialect, age, any number of categories that deviate from the white male standard that these ASR engines were trained on, you're getting these self-perpetuating algorithmic biases mixed with AI hallucinations, and it's a recipe for disaster. So we already have these conversations in our justice system about bias, and we need to be able to answer these concerns as courts. We cannot introduce an element that has already been shown to have problematic bias. We cannot answer those concerns if we already have them before we implement them. So we can effectively cross that one off the list. Number 4 on the list is privacy and data protection. Any new tool that gets introduced into a government system or sensitive data must comply with all existing privacy regulations and standards. It has to hit anonymity, confidentiality, and control. And we know from data breaches, from these outsourcing concerns, from data scraping, people from using these ASR engines and the information that you're feeding in being scraped out and used for future translations. All of these are breaches of that privacy and responsibility. And according to the ABA, you are now responsible for that breach, even when using a note-taking app. So it definitely does not check the 4th box. 5th box is accountability and responsibility. This is a direct quote from these standards. As public stewards, departments should use generative AI responsibly and be held accountable for the performance, impact, and consequences of its use in agency work. It is word for word what we've just been saying. It's the human in the loop question. When something goes wrong, who gets subpoenaed? Which person or entity was responsible from the time of recording to the time of production? Are they licensed? Are they certified? Can we even find them? Do they have any oversight, or are they beholden to any legal or ethical standards? Who is on that cert page? So we can cross that one off the list. There is zero accountability. Next one is transparency and auditability. We just talked about this. Is there a record of these AI processes and engines? Transparency means information about an AI system and its outputs are available to the individuals interacting with that system. So can I, as an administrator, see the data that this was trained on and know that it's reliable? So traceability, explainability, end user agreements. Vendors don't like to disclose the guts of their engines or their proprietary data. There's not enough transparency and auditability to answer this question. And the last thing on the list is public purpose and social benefit. This is possibly one of the most important bullet points to me when you were thinking about, should I be implementing something new in what I already do and what I already presumably do well? What problem are we solving? Are we delivering some sort of better or more equitable service or outcome? And ultimately, if we already have a good solution with our stenographers and our voice reporters, the gold standard court reporters in the room who are making the record and have been doing it for over 100 years, what problem are we trying to solve versus what kind of risks are we introducing into the system? There's no cost saving, there's no improvement or accuracy or turnaround time, and there's no public benefit.